Good afternoon, everyone. My name is Bittinger. I'm the owner of the Bittinger Law Firm and a healthcare attorney. Thank you for joining us today for our February webinar entitled, Uh-oh, we hired physician extenders and don't know how to bill or supervise them according to the rules. This is the latest in our monthly Uh-oh sessions, in which we provide education for subjects that we get calls on a frequent basis here at the firm. We try to address issues that are relevant to what we're doing here at the practice. You know, we would find that clients would give us a call and say, literally, uh-oh, we're having XYZ problems. And so we came up with the name for the Uh-oh series because we would find that clients, especially often physicians or company CEOs or practice administrators, would call us and say, uh-oh, we're having a problem. Got a few minutes to discuss it, Ann? And so as we saw trends, we developed the Uh-oh series webinars. I have muted all of your lines, and at the end of the presentation, I will unmute them so that we can share some questions and answers. So with that, let's get started. We're going to talk for about the next 30 minutes about how to supervise and bill for nurse practitioners and physician assistants. And I'd like to start with a metaphor. There's a funny saying that goes something like this. Just because you hear hoof, the sound of hoofs, or a galloping sound coming towards you in the hallway or down the street, it doesn't necessarily mean that what you're hearing is a horse. That gallop could be a zebra. And it's a nice metaphor here to use with the differences between physicians and nurse practitioners, the difference between physicians and physician assistants, and even the difference between nurse practitioners and physician assistants. So let's keep that zebra metaphor in line as we proceed for the next half hour or so. We're going to talk today about Florida law. I'm going to spend about 3/4 of the discussion on Florida law and the rules for supervision. I'm going to spend about 10 minutes on the incident to billing rules under Medicare. And that might be something that all of you are really, really, really interested in. And I don't want you to think that I'm not spending enough time on that because it's very important. But I think I've summarized it in such a way that I've made it a turnkey piece of information for you. So with that, let's go ahead and get started. So let's start off with some background, just to put all of this in perspective. Back in the 80s and 90s, when we saw the birth of nurse practitioners and physician assistants in the industry in meaningful numbers, there was really a turf war going on. The physicians, and particularly the lobbyists for medical societies, we're very much opposed to physicians giving up some of their turf to unlicensed practitioners. There was kind of an unfair idea out there against what nurse practitioners and physician assistants are really capable of doing. So 20, 30 years ago, we really saw a lot of tight rules about what nurse practitioners and physician assistants can do. Coupled with that, at that time, as many of you on the call remember, it was very much a managed care time period where we had the gatekeeper model in large mass in the industry. And so a lot of physicians were threatened that they were losing part of the managed care pie. So sort of this question about what are these people really capable of doing, coupled with the economic aspects of the gatekeeper and managed care models at the time, led to a lot of controls on what NPPs can do. And you'll see in the slides here, which, by the way, you can download from the website and keep, I'm referring to NPPs as non-physician practitioners. So when you see NPPs, I'm talking about both physician assistants and nurse practitioners. When I'm speaking about just one of those two groups, I'll refer to them specifically. So today, boy, have times changed. The expansion by the industry of greater work by nurse practitioners and physician assistants is amazing. One of the areas in health law that I practice is compliance with the Stark Law, or the physician self-referral prohibition. That is the federal law, and there's a state equivalent, that says that physicians cannot refer to entities that they have financial relationships with unless an exception is met, if it's a designated health service. And I don't mean to get on a tangent, but I bring this up because just a few months ago, the federal government revised the regulations that go with the Stark Law. And you know, these are really, really, really strict laws that physicians and executives and business people often end up in jail for, indirectly through the anti-kickback statute. Usually there's an application to both. But these are really, really strict laws that tell physicians what they can't do. For example, a hospital can't give payments to physicians unless it's really for something that's within an exception. One of those exceptions has been recruitment of physicians into an area that needs it. For example, if in Jacksonville we had a shortage of psychiatrists, the hospital would be able to pay money to a local psychiatry group for them to recruit a new physician. I'm getting on this tangent because the new Stark rules just allowed now hospitals to also pay money to groups to help them recruit nurse practitioners and physician assistants. So it just, to me, is a huge example of the emphasis by the Obama administration to get more physician assistants and nurse practitioners out there seeing patients. Certainly with the expansion, speaking of the Obama administration, of coverage mandated by the ACA, we're seeing an increased demand for primary care treatment. And that, coupled with the well-established primary care physician shortage in the United States right now, is really putting NPPs in great demand. As background, NPPs typically need only 2 or 3 years of education versus 8 years of education. So this is making this NPP industry very lucrative and very appealing to young people who feel they want to get into the practice of medicine, but perhaps not study for 8 years. In terms of the financial savings to practices, the difference is extraordinary. We have reduced salaries for NPPs, we have lowered overhead for NPPs, and perhaps some increased patient volume. That's coupled with the fact that they're usually attending to the less acute patients. But for the most part, NPPs can see more patients during the day than physicians can. NPPs free up physicians to attend to the more acute patient volume. This is a nice chart. I call it my zebra chart because it kind of shows the stripes of differences between nurse practitioners and physician assistants and physicians. Some of the more telling facts here, I think, are that there are still a heck of a lot more physicians practicing in our country than there are any NPs. So you can see the difference there between the 708,000 figure versus the 122 and 94 figures. Another telling figure is that nurse practitioners are much more prevalent in primary care than physician assistants. We often see physician assistants teaming up more with the physician specialists and nurse practitioners doing the primary care. It's not always the case, but you can see the statistical difference here is very telling. Educational programs, look at all those programs that are churning out nurse practitioners. A lot. That is a lot. And then in terms of the numbers that are important to the practice managers who are on the call, nurse practitioners' average salary, and this was for 2014, so fairly recent, was about $101,000 a year. PAs at $112,000, and then physicians at $173,000. And those were average full-time salaries. So you can imagine you could get almost two nurse practitioners for the price of one physician. You couple that with decreased overhead for them also, and it comes out to just about 2 to 1. But be warned, adding NPs and PAs isn't the same as adding MDs to your practice. You need to make sure that you enhance your practice, not endanger your practice when you add NPPs to your provider mix. That's what we're going to talk about next. So let's just go through one lesson from the trenches. This is straight out of a Board of Medicine discipline of a Florida physician. So this physician employed a number of physician assistants who practiced pursuant to no written agreement outlining the drugs that they were specifically authorized to prescribe. There was no protocol, in other words. The PAs prescribed on blank prescription forms that the MD pre-signed. We'll talk about that. That is a big no-no. And the PAs wrote a number of prescriptions for controlled substances here too, which is really bad facts and what really gave rise to the investigation by the Department of Health. This particular Florida physician was fined $20,000 for this. He was given a reprimand, which is, a written, you've been a bad doctor by the Board of Medicine, was put on probation for a year, had to do 4 hours of continuing education. He also had to do 100 hours of community service, and that's the equivalent of about 2.5 weeks just seeing patients. If you think of a 40-hour work week, 100 hours of community service, and have a licensed healthcare risk manager come in and do a review of his practice. So you can see how important it is to make sure that physicians are properly supervising their non-physician practitioners. It's interesting, in my practice, a lot of the calls that I get in this area are about how do we bill for incident to billing? How do we get that extra 15% for Medicare? And I'm going to talk about that at the end of the call. But I say to my clients when I get calls about this, okay, here's how you got to do that, but what are your supervision protocols like for this nurse practitioner? Do you have everything down that you need? Because frankly, getting an extra 15% from Medicare is not nearly as important as saving your license. This kind of discipline is on your file forever. It's reported to the National Practitioner Data Bank. Florida Blue learns about it. All of the hospitals that you're credentialed learn about it. So you can see why these rules are really, really important. And incidentally, once a physician has trust in a non-physician practitioner, you kind of just go with the flow. And it's just an easy thing to lose track of and to kind of push the ticket on. So let's talk a little bit more. I'm going to go through some of the specific rules in Florida about NPPs. Now, this is from the Medical Practice Act. If you violate this act, the physician's license is disciplined. So that's the statutory scheme that we're talking about right now. So the Board of Medicine, and this is straight out of Florida statute, that's what that 458.331 is. The Medical Practice Act says the Board of Medicine may take disciplinary action against a licensed physician for delegating responsibilities that the physician knows or has reason to know that the person is not qualified to do by training, experience, or licensure. Let me repeat that. By training, experience, or licensure. What we're talking about here is negligent delegating. And you can negligently delegate to a medical assistant as much as you can to a nurse practitioner or a physician assistant, but this is the statute that they use on the NPs and the PAs too. The Board of Medicine, by statute, can also take action against a Florida physician's license for failing to supervise adequately the activities of physician assistants acting under supervision of the physicians. So we need to make very, very clear that the physicians can prove that what the NPPs are doing have been approved by the physician and that the scope is within the training, experience, and licensure of that individual. A few more laws. Do not pre-sign blank prescription forms. There is just no way that you should be doing that, ever. And let's sort of work through some of the, well, and we kind of did it like this. Is that really pre-signing? So I had one client who would sit at his desk, this is a physician, and the day before patients were coming in to be seen the next day by the extender, would go ahead and fill out all the prescriptions and sign them, and basically just have the extender do the evaluation and the follow-up. These were all follow-up patients, of course, and hand the script to the patient that the physician had already signed. That is a no-no. That is, still pre-signing a prescription form because it was signed before the patient encounter. Do not do that. Do not have the physician just sign a blank script right before the patient comes in. It really needs to be signed by the actual practitioner who performed the service. The Board of Medicine can take disciplinary action against a licensed physician for breaking any rules. That's their kind of catch-all that they use. And then the supervising physician and the prescribing PA are required to enter into and keep on file a written agreement outlining the drugs in the formulary that the supervising physician has authorized the PA to prescribe. We'll talk in more detail about that. This is the document that we call the protocol that has to be in writing. And as you can see from this regulation, it's not a default. PAs can't, by default, just by virtue of their licenses, write scripts in Florida unless the physician has, in the protocol, outlined which drugs that the PA, under that physician's supervision, can prescribe. It might seem like a minute legal distinction, but it shows how important the protocol is and the language in the protocol. So let me focus now on just nurse practitioners under Florida law. Generally, nurse practitioners can do the following as long as they do it within a, quote, established framework. Again, what they mean by established framework is the protocol or the contract between the nurse practitioner and the supervising physician. You will see that this language is extremely broad, especially in terms of what they can do initially. Nurse practitioners in Florida can monitor and alter drug therapies. They can initiate therapies. They can order diagnostic tests. You do not need to consult with the physician before ordering a diagnostic test or initiating treatment. Now, there's a little caveat there if you want incident 2 under the Medicare rules, but we'll get back to that in a little bit. So what you have to do is explain in the protocol, and the following five bullet points there are things that nurse practitioners can only do according to the protocol. So not to harp on how important the protocol is, but again, the protocol has to say that they can do these things or they can't. If you have a nurse practitioner who might routinely be ordering PT, physical therapy, or occupational therapy, the protocol has to say it. If they're going to manage selected medical problems, if you had a nurse practitioner who's really doing ongoing management of diabetes patients, your protocol needs to say that. If the nurse practitioner is initiating, monitoring, or altering therapies, you need to say those, and you kind of need to say somewhat broadly, but with some specificity, what the illnesses might be. It doesn't have to get down into each and every ICD-10 code number or description, but somewhat generally needs to be explaining these things. If the protocol says that they can monitor and manage patients with stable chronic diseases, which is what a lot of nurse practitioners do, then your protocol needs to say that. You can kind of copy and paste from this list and then expand upon it in order to meet this statute that I have cited there. So let's take a step back. We just talked about what nurse practitioners can do. Let's talk about who can supervise nurse practitioners. Under the Florida Practice Act for nurse practitioners, a medical doctor, a DO, or a dentist can supervise ARNPs. Chiropractors cannot supervise ARNPs, nor can PTs or OTs. Even within those three categories, the specialty of the physician has to match what the nurse practitioner is doing. For example, if a practice says, we'd really like to expand into a related specialty line. Let's say we have a family practitioner who sees a lot of patients that are perhaps behavioral health patients. Let's say this family practitioner has absolutely no background in psychiatric work, but he brings on a nurse practitioner who has experience working with psychiatric patients. That is a no-no. Unless the physician has experience in the actual sort of subspecialty work that the nurse practitioner will be working in, he can't supervise her or she can't supervise him. Sorry, a little gender mix-up there. So the physician cannot supervise a nurse practitioner unless the physician has experience there. So do not, practice managers, think that you can expand into a new service line or a new subspecialty by bringing on a nurse practitioner to do it. You can't. There are also special rules if you're in the plastic surgery, aesthetic, or dermatology world on Florida law, and we'll talk a little bit more about that in a few slides. So what does the protocol have to say? I know I've been badgering on the need for the good protocol. This is exactly what the reg says. And if you go to the Board of Medicine publication, if you Google what I have there in italics, you'll see their model form. It's pretty good. It's not great, but it's a nice template to get started, is what the board says. You can't just print it out and sign it. Let's put it that way. So this document has to be in writing. It has to be signed by both the physician and the nurse practitioner. It has to have the name, address of the nurse practitioner and his or her certificate number. Has to have the name, address, and license number and the DEA number of the physician or the dentist. It has to describe the things that we just described, the nature of the practice location, and any primary or satellite sites. So what this does is it tells the board what kind of place is this nurse practitioner working. We're a primary care practice located in Jacksonville, Florida, with 2 satellite locations, and our patient population is predominantly XYZ. Just kind of a little opening paragraph there. It has to say the date developed and the dates amended, and if there are amendments, those need to be signed, and the whole thing has to be signed. It has to describe the duties of the nurse practitioner, as we just talked about, and then a description of the physician duties and backup in case the physician is not available. So if the physician's going out of town on vacation, is otherwise not available, we need a backup physician there, at least on the records here for the Board of Medicine. Now that doesn't mean if there's an emergency and you call Dr. A, you need to know at all times that Dr. B is available. It's not that per emergency situation specific, but they want to know that there's some sort of a backup. And then finally, as we talked about, it needs to describe the conditions for which the therapies may be initiated. Continuing on, treatments that may be initiated by the ARNP, the drug therapies, those all have to be described too. There is a provision for annual review by the parties. So as much as I don't want you to minimize your computer screen right now, if you need to go to your calendar right now and enter, February 1st of each year and do it a recurring calendar to make sure you review ARNP protocols annually, do so. That is a requirement by the Board of Nursing. And then finally, if there are specific conditions in which the physician wants to have direct evaluation of anything, kind of need to say that. So let's step back for a minute. What this means is the physician and the physician assistant really need to have a dialogue about the scope of practice of the nurse practitioner. What are things that he or she can and can't do without touching base with the physician? Most importantly, what your physicians need to ask themselves is there anything that I do not want this nurse practitioner to handle without coming to me? And so that's kind of a backwards way of saying what she can do if you say what she can't do. You know what I mean? So the parties I have here in quotes need the protocol to ensure the acceptable standard of supervision and medical care that talks about the conditions in the treatments and that considers the risk, education, and experience and complexity and the setting and availability of the physicians as factors. So there might be some things that you might let some nurse practitioners do because of their experience that you might not let another one do. And as the lawyer, the question that I've seen my clients get is, counselor, why did your physician do this knowing that that nurse practitioner had just graduated from school? So you want to make sure that you're not letting them do something that perhaps they don't have experience doing. If you think you're pushing it, I do review these for clients in kind of a defensive, proactive way to ask some questions and to sort of phrase the language right so that they're done properly. So once you have the protocol done, what do you do with it? You have to file it annually. Again, if you need to minimize the PowerPoint presentation and go add something to your calendar to make sure that these are filed annually and that you have a reminder to do so, then do it. You can get in trouble if these are not filed annually. You also have to keep them on copy, keep a copy at the site of each practice location of each party. So if the nurse practitioner goes to 2 sites and the physician's only at 1 site, you have to have it at all those 3 sites. Every site that the physician goes, even if the nurse practitioner doesn't go, has to have a copy on file. I've been asked, well, if we have it on our intranet site, is that good enough? Because we can always pull it up. Yeah, I kind of think it probably would be okay, but it's not something that I've seen the board actually opine on. I think that if you had a policy in your office that said it would always be available on the intranet, then that probably helps rather than just kind of sticking it there and not telling your physicians and nurse practitioners where they are. If you make any alterations, an update has to be filed in 30 days, and there is a requirement that these protocols be maintained for 4 years after the relationship ends. I'd like to talk for a minute just about drugs because that's where we get lots of questions. So within the framework of analysis here, I'm talking about Florida, nurse practitioners, and what they can do with regard to drugs. Nurse practitioners can prescribe drugs pursuant to their protocols. So usually what we do is write them so that there are categories of drugs that they can prescribe. Some of those are pretty straightforward. Sometimes it gets a little dicey. They cannot prescribe controlled substances. In Florida, they cannot prescribe controlled substances. Don't even go there. If you're in a situation where you're treating a patient and they say, oh, if the nurse practitioner, let's say, is treating a patient and then they ask for a refill of their controlled substance, whether it's for pain, whether it's for psychiatric purposes, that nurse practitioner has to know that the physician needs to be consulted. And your practice procedures have to have a way for either scheduling that patient to come back or by working that patient into the physician's schedule, with the physician doing all the evaluation that needs to be done to rewrite that script. So be very, very careful about how that works. What cannot happen is the nurse practitioner goes out and then comes back in with a script for the controlled substance. In that situation, the physician absolutely has to have a face-to-face with the patient and document that the physician did everything that needed to be done in order to write that script. All right? That's where people get into a lot of trouble. As I'm sure you probably know, the nurse practitioner's name appears on the drug container. That is fine. Not all states are that way, so there's sometimes some confusion about that. And nurse practitioners can dispense meds, just like physicians can dispense in their offices. They just have to register to do it as a registered dispensing provider with the state. No problem. Just make sure that you pay the fee and do that. As some practices have really gotten into the dispensing world, I've had a few clients who registered their physicians but didn't register their nurse practitioners as dispensing providers. It's an easy thing to overlook, so make sure you do that. Here's where there seems to be the biggest myth. There's no legal requirement for MDs to sign off on or review the charts or the medical records of the patients that the nurse practitioners see. If you're weighing whether to hire a nurse practitioner versus a PA, know that the PA's rules are different about on this for a short time period at least, but physicians do not need to review or sign off on or initial the medical records of nurse practitioners. Is it a good idea to do it at certain points in time, such as on new hire or on expansion of their scope? Absolutely. Is it smart to perhaps do periodically just to make sure you're on the same page as sort of an audit? Absolutely. But it is not something that needs to be done for each and every patient. I'd like to turn now to in-office supervision. And again, the scope that I'm talking about here is Florida law. Incident to billing is a completely different world. But in Florida, on-site or in-office presence of the physician, the MD, DO, or dentist is not required by law or reg. However, the physician can go ahead and require it if he or she feels that's necessary, considering the situation. So it's not required, but a physician could say, you know, if you're seeing this type of patient or doing this type of procedure, we're only going to schedule those on days when I'm here and in the office. There's one exception, and this totally comes out of a silly turf war from a few years ago. A physician has to be on site for electrolysis. A little curious, but it is what it is in Florida. How many nurse practitioners can a physician supervise? There's actually no specific limit in Florida except for satellite locations, and I'll talk about that in greater detail on the next slide. There are physicians in Jacksonville that have 5 and 6 nurse practitioners working in their offices with them, and that is perfectly fine as long as that physician has explained or can document and prove what I have here in quotes. So the number, you can have any number you want, basically, says the board, as long as you can prove to us that you've ensured that it's an acceptable standard of medical care, and that's being rendered based on the risk to the patient, the educational preparation, specialty, and experience of both the physician and the nurse practitioner, the complexity and risks of the procedures that are going on in the office, what kind of practice setting is it, and then how available is the physician. So, you know, the more nurse practitioners you have in the office, the more you want to know that the physician's always there, that it's for fairly non-acute, routine treatments that are going on, and that these nurse practitioners and the physicians are very experienced. So there's sort of a correlation in reverse there. The more you have, the more you want to be able to prove that everybody knows what they're doing and that there's no risk to the patient. So this is an area where I often get involved, is sort of writing a note to the file or a memo to the file to help document how my clients have gone through this and analyzed it and documented it. So let's turn now to satellite locations. So a satellite is basically where you might not necessarily have the physician there ever, or perhaps not at all. So in primary health care, the physician can't supervise more than 4 offices in addition to his or her primary office. For the purpose of that 4 offices rule, that doesn't apply to derm and skin and aesthetics. So what that means is if the physician is basically at one location, like the hub of a wheel, and coming out from the hub are 5 different other locations, that's too many. And it's based on offices rather than nurse practitioners, so offices rather than humans. So you can't have your physician in one hub and then have 5 other offices that one nurse practitioner goes around to 5 different days of the week. Different rule for specialists, it's 2 offices. And then if you're derm or aesthetic, it's a little bit more complicated. It can be only 1 office, it has to be within 20 miles, or a continuous county, not less than 75 miles away if the counties are contiguous. The supervisor must be board certified. So that whole derm plastic rule had to do with the rise of medical spas about 5 years ago. What we found was that you'd have a physician and 7 nurse practitioners, and the physician might be in New Jersey and be down his medical record and maybe show up in the state once in a while. And there was a lot of bad things that were happening there. So that rule is to combat that sort of a thing. So that's why it's so strict in the derm and aesthetic setting. A physician who supervises an office in addition to the primary location must conspicuously post in each of the physician's office a schedule of the regular hours when the physician is in the office and the hours when the office is open while the physician is not present. This rule is rarely complied with. I know from just my own medical treatment that I rarely see this. So make sure that this is being posted. There's some other rules about postings that I'll get to, but you need to have something up in your office that says what these hours are when the physician will be available. Again, this is just on satellite locations. All right, so we have finished with our discussion of Florida law on nurse practitioners, and now we are switching to PAs. And transitioning from the last slide, I thought we'd talk about first how the physician assistants have to identify themselves. Very interesting. This rule is in no way, shape, or form in the nurse practitioner law. It's only in the PA law. So you'll notice after each one of these bullet points, there's an or. So the physician assistants have to do either the first, the second, the third, or the fourth, or the fifth of these items listed here. Sometimes it seems like the 5th one is the easiest to comply with, and that is place a notification in the lobby or the waiting room, which contains a photo of the licensee and identifies the licensee as a physician assistant. This is usually done very tastefully with beautiful photos that have the name of not just the physician assistant, but also all the physicians in the practice. It can be done very tastefully. It's a nice option for those of you practice administrators who are on the phone who don't want to make sure that your PA is wearing his lab coat every day that has his or her name on it and says that they're a PA. But you can do that. That's the first or second one. You got to love the language of these regs, don't you? wear an article of clothing on the upper body, which identifies the licensee as a PA or basically wears a name tag. They can wear the name tag anywhere, apparently. The name tag does not have to be on the upper body. Another option is that the PA walks in and says, "Hi, I'm a physician assistant," identifies himself on the initial in-person contact, or hands out a business card. I think this is something that's not followed very much either, so it's definitely something to pay attention to. This is another one that I don't think is complied with often. The physician assistant must say you have a right to see the MD, almost like you have a right to an attorney under the Miranda law. Florida law requires that the physician assistant inform the patient that the patient has a right to see the physician at any time prior to any prescription being prescribed. So if it's just a follow-up in which there's no prescription, you don't have to. But this is kind of a quirky rule here that says that if they're getting a prescription, they have to be told that they can see the physician. Usually that's in the form of, okay, everything's good, here's your script, do you have anything that you actually need to see Dr. Smith for at this time? And that usually goes fine. How do we document that this was done? We put it in our EMR and we check that box as we're writing the script. Switching now to a little bit more general rule about physician assistants. Every PA has to have a protocol with a supervising physician. Here the rules are much similar to the nurse practitioners. The supervising physician is, as we talked about in our situation on the discipline of the physician earlier, the physician's individually responsible for what the PA does. Physicians need to know that they are personally responsible for what that PA does. PAs are governed by the Council on Physician Assistants, and there is a maximum here with physician assistants, very, very clear. And you can see why the zebra stripes, my metaphor of the zebra versus a horse. The zebra of physician assistants, MDs can only supervise 4 PAs, period, versus sort of the horse of nurse practitioners where it was no limit unless there's a satellite. So very, very, very different there. What can PAs do? Similar to NPs, they can do anything that's within their protocol and their formulary as long as it's within the supervising physician's scope of practice. So just like with nurse practitioners, you can't expand your practice into a new specialty that your physicians don't do by hiring a physician assistant who had worked in that specialty. What can a PA not do? The PA can't prescribe drugs unless the rules are followed. So what's interesting is that it's not sort of a default. It's not like they can just do it. They can only do it if the physician told them that they can do it in their protocol. Interestingly enough, PAs can't give a final diagnosis. Kind of seems to me a silly rule, because what is a final diagnosis and when is it final? But that's come up a few times, and it's kind of an odd rule. They cannot do things under general supervision for things in which direct supervision is required. Let's pause just for a moment and talk about general supervision versus direct supervision. This concept is very important in terms of incident to billing that we'll get to in just a moment. Direct supervision means that the physician is there in the office. Doesn't have to be in the room, doesn't have to be looking over the shoulder, but is in the office. We'll talk a little bit more about certain caveats in the federal law, but basically it means they're on site. General supervision means they're checking in with each other every now and then, and they have a protocol in writing. So general supervision is, ironically, very general. But direct means on the premises for the most part. So the PA is limited by the agreement. They have to keep on file the agreement for what the PA is specifically authorized to do. It has to be signed and dated, and here kept on file for 5 years. PAs do not have to send them in. unlike the nurse practitioners, you just have to keep them on file and have them available on request. PAs can work in any setting, again, that is within the scope of practice of the supervising physician. MDs, DOs, and chiropractors can supervise PAs. So you remember, chiropractors were not on our list when we talked about nurse practitioners. With PAs, chiropractors can supervise, dentists can't. You can see it's an animal of different stripes. The level of supervision, again, direct. For purposes of Florida law, with PAs, direct means on the premises and immediately available. Indirect, which is different than general, indirect means easy availability, including telephone communications, and within reasonable physical proximity. Now, we don't know what reasonable physical proximity is, except for in one case, 500 miles away was not, according to the board reasonable physical proximity. So we kind of see how that one goes when we have different things that have to be done under indirect supervision. When is direct supervision required? The list here. These are pretty invasive procedures in which most physicians would say, oh yeah, of course I'm going to be on site when this happens. Maybe some of the cardiac stuff might be done by a really experienced PA without the physician being on the site. But for the most part, these are pretty heavy-duty things. The corollary is that direct supervision is not required by Florida law if it's not on this list. So you can see that as long as the physician has in his or her protocol what the PA can do, they can do pretty much anything except for these 6 items here. Again, subject to the caveat that they've gone through the experience, the treatment, the risk to the patient, and so forth. So what is reasonable supervision? Similar to the nurse practitioner statute that we talked about a little bit ago, we're looking at the things in the 3rd bullet point there. The complexity of the task, the risk to the patient, the background of the physician, the training, and the background of the PA, so on and so forth. So you need to kind of chew on these issues, go through them, and make sure that everything has been addressed in the protocol. If you want to change your protocol, or if the PA changes and has a new supervising physician, or opposite, if the supervising physician leaves, the PA has to notify the council in 30 days. Make sure that you do that. Another quirk, and I've seen a client get in trouble for this one, is if the supervising physician leaves the practice, then the PA's prescribing privileges are immediately stayed until a new agreement is in place. So again, you'll see how I pointed out the concept of the PA can really only prescribe what the protocol says he or she can prescribe. There's really a default that says they can't do it unless the protocol is there. If the protocol is, in a sense, void because the physician is no longer employed with the same group, and that PA is prescribing, there can be trouble with the council and the Board of Medicine. Let's just put it that way. So administratively, we need to make sure that these things are kept up. When you're an administrator of a practice that has 500 physicians, this can be very difficult and time-consuming. So it's best to put in place some sort of a protocol management system so that it's on your list of things and that you're flagged to do this when a physician leaves the practice. All right, so now we have a nice slide on drugs just for PAs. PAs can't have DEA numbers, not in Florida. And again, the prescription authority is not automatic. There's no default. And there's a lot of rules here. PAs that prescribe have to have evidence of 3 classroom hours in prescriptive practice and 3 months clinical experience, so on and so forth. This is the rule where you have a right to see a physician statement comes from. The prescription has to contain the supervising physician's name. That's not something that's in the nurse practitioner's rule. And it has to have the phone number and the prescribing number. Another area where I see a lot of falsity is that the supervising physician doesn't have to countersign scripts. I have so many physicians who go around and countersign PA's scripts. Don't need to do that. Don't need to do that. You don't need to make photocopies of the scripts. As long as the PA puts notes on the prescription in the medical record, and then the supervising physician reviews and signs the notation, that's enough. And we'll talk a little bit more about that rule. And remember that you can't dispense samples unless you can prescribe. Where folks get in trouble with that is that there are still, believe it or not, practices that will give samples of controlled substances. Don't let your PAs hand those out, if you even have them in your office at all. Usually we see that in the behavioral health world, but and not so much in the pain management world, but be very careful. The PAs are limited by formulary. If the formulary doesn't list the drugs, then they can't prescribe them. So oftentimes it's easy to do it with categories. You don't have to go and list every single drug that's out there on the market, but do it by category. And if there's anything that you don't want them to prescribe, carve that out. All right, so now we are done with our talk about Florida law. I'm going to move now to incident to billing. And this is really a financial component. All we're talking about here is how to get paid by Medicare when a nurse practitioner or physician assistant sees the patient. So this rule that we're going to now is only a payment rule. If you do not follow this rule, that doesn't mean that you've violated the Nurse Practice Act or Board of Medicine Act. You haven't violated anything under Florida law. The only slap on the wrist that you get is you get paid 15% less from Medicare. So the incident to billing rule comes from the Medicare Carrier's Manual. So technically speaking, we're only talking about Medicare patients. Now, you and I all know that it is very difficult to put in place a procedure for incident to billing for each and every payer rule. I often get asked, well, does this rule apply to the private payers? And it seems like most of them follow it, but it's all over the board, especially as to new patients. So I encourage my providers to contact the payers, to go on the website to see what rules they have, because they also seem to be changing a lot too, as it seems the industry is putting a bigger emphasis on what NPPs can do. But this is not a private payer rule, technically speaking. This is only a Medicare rule. So if you meet the criteria of the rule, which I'll talk about on the next slide, then the services of the NPP are billed under the physician number, and you are paid 100% of the physician fee schedule. So whatever the physician would get paid for doing it, the nurse practitioner gets paid for doing those services, basically. It's billed under the physician's number and gets paid at 100%. If you do not meet the rules that are on the next slide, then it may be billed under the nurse practitioner's own provider number, and you get paid at 85%. So there's a 15% deduction for what's paid for that visit. I've had practices say, well, what do we do because we never got Medicare numbers for any of our extenders, and we've just billed everything under the supervising physician's number. And that's when I start talking about Medicare disclosure rules and repayment rules, because that is completely illegal. And Medicare wants that money back. Not only do they want probably everything that you've billed. They don't want just the 15% back. They want everything back. You now have a requirement to self-disclose that to Medicare and to repay it on your own. So very, very serious stuff here. Also, incidentally, this has been on the OIG's work plan for on and off now for about the last 10 years. It's something that they're looking at for certain. So let's get into what these rules actually are. And I said at the beginning of my talk that, in essence, this is pretty simple stuff. The law itself is pretty simple. How you operationalize this in your practice can actually be fairly complicated. The main issue that I'd like you to circle here, if you've printed out the materials, is the bullet second from the bottom with the gray dot. The physician must be present in the office suite and available to assist the NPP. So you have to be in the office suite. I can tell you in my 17 years of practice, we have gotten into very interesting discussions on what is the office suite. Are you in the same suite if it's upstairs in the medical office building, and the hospital who owns the medical office building actually calls that 1700 and we're in 1600. Is that the same suite? Is it in the same suite? Do we have to build stairs, a spiral staircase going upstairs? It can get very interesting about what it means to be present in the same office suite. But that's the rule. That's where the lawyer gets involved in sort of talking about how we can make it proven that you're in the same office suite. That's really the main one, other than the first bullet, and that is the new patient rule. Technically speaking, under this rule, if it's Medicare, new patients can't be seen by nurse practitioners if you want the 15%. They can't be seen by PAs if you want the 15%. They can go ahead and see them, but it needs to be billed under the nurse practitioner's or PA number. So the rule is that the incident to billing service has to be integral, although incidental, to the physician's professional service. The interpretation of that is that it is not incidental to a physician's service if the physician hasn't seen the patient. It's not integral to the physician's service if the physician hasn't seen the patient. Where this gets more complicated is, well, what if we've always seen the patient for asthma, and then during an asthma recheck, she tells me that she's got a sore elbow? The treatment of the sore elbow is not incident to the plan of care that the physician started for the asthma. So at that point in time, the physician needs to get involved, or the 15% deduction applies. There's some other funky language in here, but for the most part, those are the two things that you have to keep in mind that have to be done. How do you document this? You know, as a healthcare attorney, I try to proactively help practices so that they have in place systems so that if they are audited, they have something to rely on. Keep a chart, a calendar, in some way, shape, or form, document when the physician is on site. Some practices like to go to the degree of having the physician sign off on notes or review the records. Certainly that's one way to document that the physician was on site. It doesn't have to be that way. A simple Outlook calendar that you just simply type in, physician is in office A today, physician is in office B tomorrow, that sort of a thing, so that you can go back and pull those calendars and say, yeah, this is where he was. That sort of a thing. Some way to document it that isn't as onerous as having the physician go to the medical records and make documentation is usually what I suggest. Again, there's no requirement in the incident to billing that physicians co-sign charts or pop their head in and say hi to the patient. You can bill under the physician fee schedule for the full 100% as a nurse practitioner or a physician assistant without the physician seeing the patient that day. So in summary, definitely if you are a practice thinking about expanding and you're doing the business planning, make sure that you include these supervision rules in your thought process when deciding whether to choose a PA or an ARNP. Again, the biggest differences are chart reviews with the PA employment, and then also as to the the satellite locations, the rules are a little bit different, and the number of physician assistants that the physicians can supervise. It's definitely a good idea to perform a risk assessment and to kind of go through and use this presentation to review your protocols that you have in place. I will say that a lot of the professional liability insurance companies have risk managers retained who can come in and sort of help you with this process. And that's a nice service that many of them provide for free. You might want to run your protocols by your attorney, and you might want to document in the protocol itself why you decided what you did. So Mary, the nurse practitioner, is straight out of school, so this is why we're having her do only these things. Or perhaps more important, Sally, the nurse practitioner, is 17 years out of school and has worked primarily in this specialty, and that's why we're letting her do all of these things that we might not normally let her do. And whether you put that in a protocol or in a memo to the file, that sort of thing, it's a great thing to go through. For clients who have gone through this, they've actually found it to be helpful, not just for legal compliance purposes, but also for treatment scope and actual operational issues. So with that, I am going to unmute all the mics. And let's see if I can unmute all the mics here. We will ask questions if anyone has them. Just a second here. There we go. Unmute all. Okay. Now's the time for free legal advice. Can anyone raise their virtual hand and shoot a question out?
I think I understand what you're saying. You'd have to raise your hand.
All right. Feel free to email me or give me a call if you have any questions. And with that, we'll conclude our February session of the Uh-Oh series. And we hope to see you again virtually via the webinar next month. Thanks very much.